Narachan wind farm. And my name is Lorna McCallum. I'm the reporter appointed by Scottish ministers to carry out an examination of this certain Section 36 application by Energy Contour UK Limited for 11 turbines on land at Narachan Hill, east of Tainloan, Argyll. And the purpose of today's meeting is to discuss the procedural arrangements for the inquiry as set out in the circulated agenda. As usual, there's no discussion of the merits of the case. So can I just address some housekeeping points before we begin? I'm presuming everyone can hear me okay? Most people taking part will be familiar with the technology, so anyone who's not actively speaking, if I could ask you to keep your mic on mute, please. And any observers who won't be speaking, if you've got difficulties in connection, it helps if you turn your cameras off. It helps with the quality of the webcast. If anyone has any questions at any point, if you could just raise your hands, and I'll do my best to try and see when I'm working on 2 or 3 screens here. The meeting today is being live streamed and will remain available to view on the DPA webcasting site. By participating today, you're consenting to the recording, storage and making use of the material for webcasting, training and the keeping of records and the making of those records available to the public. You can just check everyone's got their phones off or on silent. Okay, I'll begin. Following our discussions this morning, I'll issue a note of the meeting and this will set out all the procedural arrangements and the relevant timeframes. Has everyone got a copy of the agenda? Moving on to item 2, the parties present today. The only person I can see that is missing is Dr. Lee. I'm hoping that she's able to listen in, or at least if not listening live, can listen later, so she's aware of what is being agreed today and what the procedures will be. So as far as I can see, all the other parties who've confirmed attendance are represented. Can I turn firstly to the applicants and ask them to introduce themselves, please?
Yes, good morning, Mum. So my name is David Hardy, that's Hardy, duly qualified as a barrister and a solicitor, but for your note, I'm a partner in CMS, Cameron McKenna. I've also got Mr. Keith Campbell, who is on screen as well, from the Edinburgh office, and then Craig Potter, who is the applicant's project manager. Can I just say this, that you can probably see I'm actually in a car above Girvan on the west coast. I'm on the Ayrshire coast. If there is a problem, then Mr. Campbell will take over from me. I hope there won't be, but if there is battery falling away or whatever, then he'll study my shoes.
Thank you, that's appreciated. Okay, and turning now to Nature Scott, please.
Good morning, ma'am. My name is Douglas Milne. I am a partner at Morton Fraser. I am accompanied today by Claire Masson, Operations Officer of Nature Scott, and also I have a colleague, Cameron Gregg, with me here. Other representatives of Nature Scott may be listening in, but those are the formal attendees for the purposes of today.
Very much. Yeah, and for the council, please.
Good morning, ma'am. I'm Arlene Knox. I'm a Senior Planning Officer for Argyll and Bute Council, and I'm here alone today.
Thank you very much.
Thank you.
Okay. Right, moving on to agenda item 3, the Code of Practice. Parties taking part will probably be aware, but for the benefit of those who are not familiar with this process, just explain that there are no prescribed rules for the conduct of inquiries held under the Electricity Act. The DPA has therefore published a Code of Practice for handling inquiries under that Act. The code is modelled on the most up-to-date procedures that apply to planning appeals, as set out in the Town and Country Planning Appeals Regulations 2013. It sets out procedures to be followed and aims to ensure that proceedings will be conducted in a proportionate, fair, transparent and efficient manner. Most of the parties present will be aware of and will be familiar with the code. It's also available to view on the DPA website, and I have provided a link to that in the agenda. The parties should refer to the Code of Practice for further guidance on the matters that we will address today. Do any parties have any comments on the code, or shall we move forward? Thank you. Okay. Put item 4 on just to clarify whether or not there's been any changes to the parties' positions. Obviously, there's a few things happening in the background, not least NPF 4. So I just wanted to check that everyone is still of the same position as stated in the position statements.
If I can start, then on the 6th, we sent an email suggesting a scope of additional matters. So there's no change other than proposing an update to the LMV cumulative assessment as it relates to the North Arran NSA. I take it that you will have seen that.
Yeah, I was just about to come on to that. So what I was going to do is that you've said that you will have that produced by the 23rd of January. So I was going to discuss the timetable under item 8, but are parties happy to agree the cut-off date for the cumulative assessment as being the PEM as proposed by the applicant? No objections, okay. Thanks for getting that to me in advance of the meeting today. That was helpful. Okay. I will need to address the need to provide confirmation regarding the additional information that's being provided and whether or not this is required for the purposes of the inquiry and falls within the Regulation 26 of the Electricity Act. So I will address that in the note of my meeting.
Yes. The answer is very quickly, yes, it is. And just to be sure, or to be certain, we'd ask that you provide a notification that it is required. I think that's the safest thing to do procedurally.
I'm taking some notes. I'm working to quite a tight time frame, as you probably anticipated, but I'm hoping to get the note of this meeting out very quickly. So I will be making notes as I go along.
I have some comments to make on the proposed further environmental information and wonder, is it most convenient to wait until talking about the timetable before doing that, or would it be helpful to discuss that now?
I think it's probably better if we wait. I was really just wanting to see if there was any fundamental changes in any of the parties' positions. So if we can talk about how we address things under item 7 and the timing under item 8, would you be happy with that?
Absolutely.
Yeah. Okay. Okay, we're moving quickly on to item 5, which is the provisional assessment of the main topics requiring further procedure. So appendices 1 and 2 of the agenda set out my preliminary thoughts on the means by which I propose to gather evidence to write my report for ministers and the provisional list of the matters to be addressed in this case. I will shortly seek parties' views on those, and as already noted, I'll be addressing timing under agenda item 8. The report to the Scottish Ministers will take into account all the environmental information submitted by the applicant, together with all the consultation responses and letters of representation already lodged. The type of procedure being followed or the absence of any further procedure is not an indication of the importance of a particular issue. And for the benefit of parties unfamiliar with the process, particularly Dr. Lee, if she's not able to participate actively today, I just want to run through what the procedures are, just so that it's clear. So for inquiry sessions, witnesses for each party will be invited to prepare recognitions in advance of the inquiry, which is essentially a written statement of the evidence to be led. The evidence will be presented in turn and will be the subject to cross-examination by those holding opposing views. I'll also have questions for the witnesses, and finally witnesses may be re-examined by their own lawyer or representative. Hearing sessions take the form of a structured discussion between parties, which is led by myself. There is no formal hearing of evidence, leading of evidence or cross-examination, as well as presenting their own case. Parties can respond to what others have said. There's no need for legal representation, and although parties' lawyers can take part in discussions, there's no need for them to be present if they don't have one. Hearings are generally much more informal than inquiry sessions, and anyone who's advised that they want to take part in the inquiry process, such as Dr. Lee, can participate in the hearing sessions. I'll prepare an agenda for each hearing session based on the hearing statements that will be submitted by the participant parties in advance of the inquiry. Draft agendas will be circulated for comment in due course. Further written submissions would be requested on some topics as set out in the agenda. These may arise through responses to specific questions from myself and may range from broad invitations to submit views on a topic to specific questions on detailed matters. Topics where I've indicated there's no further procedure, I've just clarified that it doesn't mean that these are not of importance. It's simply an indication that I consider that I've got sufficient information to write my report for the ministers on that topic. What I had hoped to do was have a chat with Dr. Lee present today, just to discuss what the arrangements would be for an individual given evidence. I'm happy, Dr. Lee, if you can hear what is happening, or once you've listened to the webcast later, if you have any questions, please contact the case officer and we can clarify any points for you. So proceeding at the moment on the basis of a virtual inquiry, I will discuss the actual arrangements when we get to agenda item 7. And as set out in Appendix 1, I'm proposing that we have one inquiry session on landscape and visual impact, including aviation lighting. I propose that this would address the matters set out in Appendix 2, which is namely methodology, landscape and visual effects in the North Arran National Scenic Area, wildland area, and the plateau, moor and forest, coastal glens and rocky coastland landscape character types, impacts and settlements, road, ferry and recreational routes, and tourism and recreation receptors, and aviation lighting. Assessment of the siting, design, scale, height and layout of the proposed development, including site access and consideration of the comments and consultation responses and representations. So we discussed participation in the inquiry sessions under agenda item 6. I'm proposing 2 hearing sessions, one relating to energy and planning policy and the other relating to conditions. In order to report to ministers, I need a clear understanding of the parties' views on policy matters, including their respective positions in relation to National Planning Framework 4. The Scottish ministers will, irrespective of my recommendation, require a set of conditions to be provided. And the focus of the proposed condition hearing will be on those where there is no agreement. Any discussions and conditions are, of course, without prejudice basis. I'll just note at this point that I may need to seek further written submissions from the relevant consultees on the proposed conditions. Moving on to the further written submissions as proposed in the agenda, I'm proposing to cover 2 topics, firstly ornithology and secondly socioeconomics and effects on tourism and recreation. In terms of ornithology, where a proposed development would give rise to likely significant effects on the special protection area, the Minister, as the decision maker, has to undertake an appropriate assessment under the habitats regulations. I will need to address that matter in my report, and I will need to be satisfied that I've got sufficient information to allow an appropriate assessment to be undertaken and for a conclusion to be reached on the effects of on the special protection area. So in that respect, I'm likely to be seeking an update of the RSPB's position because they haven't responded to date on the additional information that was supplied. I'll also be looking for further information from NatureScot regarding the effects on the integrity of the Argyll Goose Roost SPA and be seeking additional information regarding mitigation and conditions. And in terms of socio-economic impacts and effects on tourism and recreation, this matter was raised in particular by Dr. Lee and in representations from other parties and in consultation responses from the community councils. Even if they're not taking part actively in the inquiry process, I do have to address these matters in my report in order to advise ministers. So I will be proposing to issue further written submission requests on that matter. Okay, so can I seek the parties' views in turn on the procedures and the scope of the topics to be addressed as set out in the agenda? I'll turn firstly to the applicants, then to NatureScot, and then I will seek some views from the council. Okay.
Thank you very much, Matt. Well, so there's, I think, a general submission from the applicant that this hopefully can be a focused set of further procedures, and I think that principally applies to LNV. The applicant's position is that there is need for an accepted need for an inquiry session on LNV, but that ought to be restricted to the NSA, including aviation lighting impacts. I'll come back to that in a second as to why I say that. And then it's agreed there should be hearing sessions for energy and planning policy and conditions. So all of that is accepted. Of course, there's going to be publication of the OWPS refresh as well as the Scottish energy strategy prior to the policy session, so they'll need to be taken into account. The only other thing I'd say about policy is it would be helpful from the council to get an update regarding the likely date of adoption of their new plan. In terms of the L&V session then, our suggestion respectfully is that can be focused on the impact of the proposal on the North Arran NSA, including aviation lighting. And we say that really for the following reasons. There's a lot of evidence on the other L&V topics in the L&V assessment and the consultation responses and representations that you've got. And we think that is sufficient to cover those matters. Failing that there aren't substantive differences, we say, in the assessment of those wider L&V topics, and it becomes a matter for your judgment and ultimately for planning balance, having taken a site visit. Third point is the topics can be addressed as necessary in statement of agreed matters, and we're proposing those, so with Nature Scot and with the councils. And I think the fourth point I'd make is that Nature Scot was clear as to the scope of the NSA objection, and they're not objecting on other topics in that agenda scope. Their views on those topics are clearly set out in the consultation response, and of course that's subject to.
Hi, can you hear me now?
I can hear you. Yeah. Yeah.
Sorry, I lost my Wi-Fi connection. Okay. Yeah. Sorry. You were saying that
there were 4 points I was making. I don't know how far I'd got through those.
I got as far as looking for an update from the council on the proposed LDP.
That's quite a chunk of material missing. Right, let me go back. As long as you can hear me, Mum. Right. So in terms of L&V, then the applicant's position is that really can be focused respectfully on the impact of the proposal on the North Arran NSA, including aviation lighting. And I went on to say there were 4 reasons why I say that. So let me just repeat those. Firstly, there's comprehensive evidence on the other L&V topics. That's in the L&V assessment, the consultation responses and representations, and we don't respectfully think that an inquiry session is required. There's a bulk of material there. Secondly, and really failing that submission working, there are not substantive differences in assessment on those wider L&V topics, and rather it becomes a matter for planning balance once you've been on a site visit. We're not sure that an inquiry session is required to look at those any further. The third point is that topics can be addressed as necessary in statement of agreed matters. We will do that with both Nature Scot and with the councils. And then the fourth point I was making was that Nature Scot really is clear as to the scope of its objection in relation to the NSA. They're not objecting to other parts in the broader L&V sense within the agenda scope. And indeed that their views on those topics is well known through the consultation responses. So our feeling, respectfully, is that the proposed scope that you set out is rather too wide, and it isn't warranted given what is actually between the parties. So that's the big submission. There was a point that my ears pricked up at the start, and that was that you were suggesting a virtual session, as I understood what you said. I think the feeling from our side is that perhaps that ought to be in person. We've got no strong views on it. It is obviously a matter for you, but we had certainly expected in-person sessions. In terms of timetable, we think this, if it's on a focus basis, is 4 days. Will fit within the 4 days, and that would be 2 days or so on L&V, and then a day or a day and a half in relation to policy and conditions.
Happy to move on to timing later. What I'm really looking for just now is just to focus on, are you happy with the actual topics and the procedures for addressing those topics? Yeah.
Yes, so it was just to say really in terms of timetable, that all fits. So we were expecting in person but focused in the L&V sense in the way that I've just set out.
Okay. Just before I move on to seek views from Nature Scott, can you tell me why you think an in-person inquiry is appropriate in this case?
Because community engagement, that's certainly, I mean, practice is varying. Every time we have a reporter taking different views, some insisting that this is part of the democratic process that's best served by having a meeting in public, in person, where members of the local community can come along and see. Cross-examination is sometimes easier. As I say, we've got no strong view, but certainly coming onto the call, given that COVID, it hasn't completely gone away, but it has retreated, given that there aren't public health and safety issues to any great extent. That would be the norm. But it's a matter for you, no strong views.
Okay. Before moving on to Nature Scott, well, the only point I would make in relation to that is that our internal guidance at the moment is to seek to deal with matters in the most efficient means, and in this case there are no individual members of the public have opted into the process. We only have Dr. Lee, so my preference would be to hold a virtual inquiry. I consider that would be quicker and easier. I'm sure everyone would like to keep time frames as tight as possible. It's quite difficult to find venues at relatively short notice. I don't have anyone who's particularly requested to participate other than Dr. Lee. So at the moment, my preference is still for a virtual inquiry.
Obviously a matter for you. It's not a strong view, but it is something that was slightly unexpected. We had been planning on the basis of an in-person event, and we have spent some time looking at potential venues, but I'm not absolutely not going to take it any further.
I won't rule it out just now. I'll take it into consideration. But can I move on and hear Nature Scott's thoughts on the proposed scope of the topics in the examination?
Thank you, ma'am. Just in relation to that point about in-person against virtual, Nature Scott is neutral on that and is happy to go with whatever your preference is, ma'am. As regards the topics, looking first of all at the LVIA session, Mr. Hardy's quite right to say that the scope of Nature Scott's objection is focused on significant adverse day and night effects on the national scenic area, special landscape qualities thereof. And that is set out in Nature Scott's letter of 22nd July 2022. So that will be the extent of their involvement in that LVIA session. It's not Nature Scott's intention to lead any evidence on the matters which don't form the basis of their objection. For example, impacts on the wildland area or broader landscape and visual impacts. Hopefully that's helpful, ma'am, in explaining what the scope of Nature Scott's participation will be in that particular session.
If you bear with me a minute, I'm still having some technical difficulties here. If you don't mind pausing for just a second, please.
Sure.
I'm a bit of trouble with my screen set up this morning. It keeps jumping from one to another. The council, I know you're not proposing to actively participate in the inquiry sessions, but could I perhaps seek your comments initially on what's been said about the landscape and visual extent of the examination process? Do you have any comments on that?
I don't think so. I don't think we wouldn't have any comment on that. We haven't objected on landscape and visual grounds, so
okay,
we leave that to the applicant and Nature Scott.
Okay. I will come back to that in a minute. I was hoping to have Dr. Lee present just to seek her views on that matter. I'd also tried to get North Ayrshire Council to participate just in terms of clarification of what the extent of their comments were in relation to landscape and visual impact. They weren't able to attend today. So what I will probably do in setting out my note will be just to seek parties' further comments on their participation in those matters. I suspect North Ayrshire Council will not want to participate, and we'll see what Dr. Lee says. But what I had hoped was that for the purposes of assisting me in writing my report, Nature Scot haven't restricted their comments to the effects in the National Scenic Area. They have made comments on wildland and in relation to landscape characters. So I feel it would be beneficial for me to get a balanced view from both parties and not simply to rely on the submissions, would be to hear a further explanation of what the effects on wildland would be. So that was my proposal in the agenda. Obviously, I don't wish to have a wide-ranging inquiry. We do seek to focus on the points of disagreement. But I would find it helpful in writing my report to clarify the position in relation to wildland, particularly when we get to considering the policy session and NPF4. So I will come on to participants in the sessions later on, but would parties be happy to widen the extent to at least deal with a further examination of the wildland issue?
Ma'am, if I may respond for Mr. Hardy in relation to the wildland issue, it's correct, of course, that Nature Scot did make comments in correspondence regarding impact on the wildland area. However, as I noted, that does not form a basis of their objection. If, ma'am, you were to seek further information from Nature Scot regarding wildland, they would need, I would need to take instructions on how much time it would take Nature Scot to be able to prepare further submissions on that. As a bit of background, Nature Scot had asked the Energy Consent Unit initially for some additional time in order to further consider the wildland issue, but that request was not granted. Wildland would require Nature Scot to go out and undertake further site visits. They would need to undertake further work before they could express a considered view. And also picking up on your point, ma'am, regarding NPF4, Nature Scot are, of course, mindful of what revised draft of NPF4 says regarding wildland, and that is a consideration in terms of their thinking as well. So, of course, Nature Scot are seeking to assist the inquiry, but at this point in time, my instruction is that they would not seek to participate in a session regarding wildland or wider landscape impacts.
And I'll give that matter some consideration. If I do come to the view that further written submissions are required on that topic, would Nature Scot be prepared to participate in that?
I need to take in instructions on that. I would anticipate that, of course, if Nature Scot did receive a request for further written submission on a topic, the response may be along the lines of what I just explained in terms of where they got to in terms of the essence of their objection. But if you were to seek that, of course, I would take instructions on that.
If you don't mind me asking, how much additional time had been requested from the Energy Consent Unit to deal with that matter?
That I don't know. I mean, Ms. Masson is on the call and may know that. I don't personally know how much time was sought.
I think it would be helpful to know if it's a significant piece of work. Ms. Masson, are you able to comment?
There had been extensions granted previously, but due to site work, including a nighttime visit up hills, getting across to Arran, and various other issues, there were several site visits cancelled, and so it got to a point where we weren't granted a further extension in order to proceed with a further site visit.
Okay, right. I'll take that matter into consideration, and I'll address it in the note of my meeting. Okay.
Just for the sake of consistency in terms of the policy session, again, it's Nature Scott's intention to participate in that session to the extent of NSA policy. As I say, that's consistent with what I've explained regarding their position on the wildland representations. As regards ornithology, I think it's your intention, you'd said, when issuing your procedure notice to seek further written submissions. It certainly would be helpful, given fairly extensive representations made already in the July letter by Nature Scott. Ma'am, if you can be clear as to the additional information, the points of clarification which you're seeking from Nature Scott, that would be extremely helpful from our perspective.
I'll set that in the note of the meeting, but it's likely to relate to providing the additional information, such as the appropriate assessment that was undertaken by Nature Scott, so that I can see what process they went through to reach their conclusions. So it's likely to be in relation to that, and I may ask for some comments in relation to the addressing some of the mitigation by planning conditions. I'm hoping to work to quite a tight time frame to get the note of this meeting out this week, if at all possible. And my intention is to get onto the ornithology topic very quickly. So that matter should be clarified, hopefully, within the coming days.
Thank you, ma'am. I have actually received confirmation it would take approximately 4 weeks for further consideration to be given to wildland.
I mean, it is a topic that I'm going to have to address one way or another when I get to writing my report, and in particular when it gets to the policy section. It would be helpful to have Nature Scott's interpretation of NPF4 in relation to wildland.
Certainly, unsurprisingly, in other public inquiries where Nature Scott has made an objection based on wildland, reporters have been seeking a response from Nature Scott regarding their view on the terms of revised NPF4. Now, that in itself, I'm sure, could be provided. It's a short update which has been provided, principally referring reporters to what the revised draft says. I'm sure that could be provided without any great difficulty. And that's part of the policy session.
Okay, thank you for that.
Can I just add to that? It's all very helpful for Mr. Milne, and respectfully agree with it. There's a compact timetable which has been. I know we're going to come onto the detail of that a little bit later, but a compact timetable that's provided, which does work. But I think it works only on the basis that the inquiry issue is focused. If there were to be further evidence required on wildland, we'd obviously need to see what Nature Scott has to say. If that's 4 weeks, the timetable is not going to work for a March inquiry. And it does, obviously, we're there to help you, as Mr. Milne says. If you want something, then obviously we will give it to you. But given that it hasn't been part of Nature Scott's objection, it does feel as though that's a sort of change, and if so, there will be, I think, reasonably profound repercussions for timetable and when this actually gets determined.
Okay, I'll take into account the comments that have been made, and then I'll consider what I think is the best way to approach this matter.
Thank you.
Okay. Right. If I could move on now to agenda item 6, which is the participation of the parties in the further procedures. Guidance note 5 attached to the agenda set out my initial thoughts on the participation. And before seeking parties' comments, I'll just run through a quick summary, again, mostly for the benefit of Dr. Lee and anyone else listening in. But the landscape and visual inquiry session, I had requested that the applicant and Nature Scott participate in the inquiry sessions dealing with landscape and visual impact, including aviation lighting. I had noted that Nature Scott only wished to address the effects in the National Scenic Area and would be content to address this matter by written submissions. Argyll and Bute Council and North Ayrshire councils have advised that they don't wish to participate in the inquiry sessions. I don't have a view of Dr. Lee other than a general indication that she wishes to participate in the inquiry procedures. So it had been my intention to seek Nature Scott to participate on a broader remit, just in order to explain its wider concerns, even if they're not part of the formal objection which it has made. Simply because I do need to address that in my report, and I need to have a full understanding of the position, particularly in relation to wildlands. So I'll give that further consideration. And it would also be helpful if, I know Argyll and Bute Council don't wish to participate in those sessions, but there is a question regarding the aviation lighting session. Argyll and Bute Council's non-objection in its committee report appeared to be dependent upon a condition relating to aviation lighting, which is not proposed. So it would probably be helpful if the council participated in that session. I'd just like to seek their further comments on that.
Thank you, ma'am. If you consider that that would be beneficial, I'm sure that's something that we could consider. I would need to go back and discuss that with my team leader and also ascertain the availability of our landscape witness.
Okay. The impacts on aviation lighting obviously have moved further forward from the position that was stated in the council's committee report. As far as I can tell, there's been further information submitted, so I'll come on to that later on, but I just wanted to be sure that I've got a fully up-to-date position from the parties in terms of aviation lighting, and that it would seem to me that the best way to do that might be by the council's participation in the short part of the inquiry sessions on that particular topic. What might be helpful, coming back to the applicant, is to clarify whether or not we're going to need an aviation expert at that session, or will it be just simply the landscape witness that would address the aviation lighting?
Yeah, we won't need an aviation witness, certainly. Whether or not there is a technical report from a lighting witness will decide, but that would be on the technical side. The qualitative assessment would then be undertaken by the landscaper.
Okay, thank you for that. Thank you. Do parties have any comments on who will participate in the sessions? Any further comments?
As regards to the conditions session, the feeling with Nature Scott is that well, they'd like to reserve their position on whether it's necessary actually to attend a hearing session. Obviously, we'll consider the schedule of draft conditions which is circulated and comment on that, but whether there is anything of substance left remaining, that exchange which would merit participation, hopefully something which can be confirmed in due course. That's
lovely, that was very helpful.
And were you asking in that question, ma'am, about names of witnesses or?
Not at this point. It was just really to get a feeling for whether or not the aviation was going to be simply a sort of landscape aviation session as opposed to a technical session, which you've clarified.
Thank you.
But that's helpful. So we've really addressed some of this, which is the policy hearing. I'd been seeking that the applicant, the council and Nature Scott all participate. I think we've addressed that. The conditions hearing, again, I've been hoping that the applicant and the council would participate, and if required, NatureScope would certainly potentially be seeking comments from the consultees on the proposed conditions. Does anyone have any comments on the hearing sessions in terms of who would be involved further? In terms of the further written submissions, I'd hope to limit the exchanges in ornithology to the applicant, NatureScot and RSPB, with if Dr. Lee had not raised any concerns in relation to ornithology, so hadn't been proposing to include her in that process, but I'll leave it for her to confirm her position once she receives the note of the meeting. Does anyone have any further comments before we move on to item 7, which are the dates and the timeframes of the inquiry sessions? Okay. So the provisional timeframe of the inquiry I had anticipated would be 3 days commencing on either the Monday or the Tuesday of the week commencing the 13th of March, based on virtual proceedings. And most parties had indicated an availability that week, with the exception of the applicant's landscape witness, who would be unavailable on the 17th of March. I reckon that if we can. So I was going to say, I reckon that if we got to happen to need the Friday, that would be simply for the hearings.
I agree with that.
Yeah, so that had been my sort of anticipated time frame. Our internal or DPA guidance note, which is available to the public on our website, sets out sort of an emphasis on setting dates in advance and trying to keep things as efficient as possible, which is why I've set the time frame quite tight in this case. Obviously, part of today's procedures is to allow parties to explain if they can't adhere to the time frames that I had anticipated. So
I think yes is the answer to that, but subject to the caveat in relation to wildland. Just while you were talking, I wonder whether this might help, hearing what Mr. Milne has to say, whether or not we could try and propose a statement of agreed matters in relation to wildland. Maybe that deals with everything, but a statement of agreed matters on wildland, and then any points of disagreement that are left over could be the focus for potentially for written submissions. But we're very keen to talk to NatureScot to narrow that issue down. I don't know what Mr. Milne whether you would find that helpful, on what Mr. Milne makes of SOAM on wildland.
I certainly don't have any issue with the applicant conversing with NatureScot to focus the inquiry. Mr. Milne?
Yes, and of course we would be willing and happy to engage in that conversation. It is, of course, subject to the caveat that if NatureScot were to give evidence, and obviously that sort of leaks into what could be agreed in a statement of agreed matters, then this further work that I'm referring to would need to be done. So yes, we can have the conversation, but we'll need to see how far we can go with that. I need to be very careful about suggesting that NatureScot can suddenly turn this these comments into an objection or vice versa without further work. So that's a conversation perhaps NatureScot and the applicant should be having directly. Now, I would like to be clear, and it is picking up on Mr. Hardy's point about timescale. I think it must be almost certain that if NatureScot were to have to undertake further work in order to assist the inquiry regarding the wildland representations, that the 13th March date would no longer be possible. What I have now had clarified is a 4-week further extension was sought from the Energy Consent Unit, but of course we are now sitting I would say the depths of winter, but I suppose winter doesn't formally begin for another 2 weeks, but the weather is not going to be ideal in North Arran. So, and I haven't spoken with our landscape expert regarding his availability. Site visits would be required, the weather would need to cooperate. So whilst 4 weeks was originally sought from the Energy Consent Unit, I can't commit to, if NatureScot were asked by a procedure notice tomorrow, please to confirm their position in relation to wildland within 4 weeks, that actually would be possible. So I think it's only responsible that I highlight that because there is that degree of uncertainty. That's why I was instructed at the outset of this meeting today to be very clear that the scope of participation would be regarding impacts on the NSA, but understand your concerns, ma'am.
Sure. Obviously, I hear what you say. I hadn't been aware that SNH's position, so Nature Scott's position, had been affected by the inability to obtain an extension to the time period for commenting. So has that influenced the comments that Nature Scott made in relation to this case? I just need to be clear in my head, would Nature Scott's position have changed if it had been given further time?
I don't think I could answer that. I think the further time would have allowed further investigation, and the outcome of that further work would have been considered and informed what the final position was.
I just need
so
to
I can't say it would have changed the position,
right.
because the work was not done.
Right. Okay. I just need to make sure that I fully understand the process that's going on. Okay. Obviously, I need to give that some thought, and that will influence the time of the inquiry. But the duration of the inquiry, even if we do address simply the matter of wild land, would that still be achievable within a week? I would have anticipated that it would have been. Turn to the applicant first.
I think that's difficult because I don't know what the extent to which that would be commented on. At the moment, it's not being taken into consideration because it's not being considered to be it's not an objection, not an issue. I think there are 2 days to deal with those issues that are between the parties in relation to the in relation to the NSA. I'd have thought 2 days on that, 1 day on planning. Recent experience has been 1 day in relation to planning policy, and then half a day in relation to conditions. That's what it feels like to me.
That had been my initial conservative estimate.
Yeah.
Okay.
I mean, just to reiterate, I mean, I got the impression if it was you're going to require further work, it would be 4 weeks or more. Then obviously the applicant would need time to consider that and respond. So I suspect it would push the inquiry back to June or something like that.
Probably most likely not available in June, I have to say. So
well, then that becomes a problem in relation to wanting to get on and expediency, and so
sure.
It's a matter for you, Mum. But I think you've got quite a clear picture from both Mr. Milner and Frost.
Thanks. Everyone has made some very helpful comments on those matters, so I will take it into consideration, and we'll decide on what I think is the best means by addressing the topics in front of me. Okay. Does anyone have any further thoughts on the duration of the timetable, Council?
Sorry, ma'am. Just thinking about March. The council's understanding was that we would only be involved in the hearing on conditions, but as you've asked today whether or not we would be able to participate in the aviation, landscape and visual session in regards to aviation lighting, we would need to ascertain the availability of our landscape consultants and council. So that may have implications for the 13th of March. But that's something that I could look into and come back to quite quickly.
If you could, that would be helpful. And if the council, are they able to participate if required in the policy hearing?
Yes, ma'am.
Yeah, that's obviously the position has changed both in terms of national policy guidance and the LDP. I think it would be helpful to have the council involved in that. I know they're not objecting to the proposal, but it would be helpful to have the council there to explain what their up-to-date position is.
We just need to make sure that the people that we would require to attend these sessions are available in March.
Is that something you could do this week, do you think? Yeah.
Yes, hopefully, yes.
Okay. would be helpful. Obviously, I'm hoping to get the note of the meeting out by Friday of this week at the latest. So if at all possible, if you're able to come back to me tomorrow, would that be okay?
Yes, I'll do my best. Thank you.
Thanks very much. Thank you. Okay. Moving on to agenda item 8, which is the arrangements and timetable for the documents, written submissions, statements and recognitions. Obviously, what I'd proposed in the agenda was a starting point, and yesterday the applicant submitted a suggested revised timetable. This has been circulated to the parties. I'll seek parties' views both on that and the agenda that I had, the timetable that I had proposed in the agenda. Obviously taking account that there may be a bit of change depending on what I decide in terms of procedures, but my aim had been to get the note of the meeting issued within the next 2 days, setting out a timetable for the inquiry and hearing sessions and for the further submissions. My draft timetable had been set out, and I'll run through it very quickly just so that it's clear for anyone listening in. Parties participating in inquiry and hearing sessions must make early and full disclosure of their case in a structured, consistent, comprehensive manner and observe the timescales that are set. So parties are asked to look at guidance notes in terms of anticipated timeframes for the inquiry of the week commencing the 13th of March. And that was based on the submission of core documents initially as a first draft within 14 days of this meeting. So core documents would be any supporting documents that the witness intends to rely on in giving evidence or in their hearing or inquiry statements, and any published documents, plans, photographs, etc. And it would be desirable if the relevant parties, the relevant parts of any documents that parties wish to refer to are highlighted and identified. The applicant should liaise with the council and other parties to produce a single core documents list and avoid duplication. The DPEA case officer is able to assist in this, and if I can refer you to guidance note 7 in the agenda. The first draft of the core document list is simply so that we have a starting point on our system and not everything left the last minute. So if we can have an initial indicative list with the documents, obviously people will know what the main documents are that will be referred to, but if those could be quickly agreed upon within the 14 days and thereafter have the majority of the other core documents added as and when they're available, and have them uploaded to our core document library as soon as practically possible. So all core documents in the final core document list I've been hoping to have 6 weeks in advance of the inquiry start date. So I'll give that further consideration in terms of when the start date would be, but 6 weeks would be our working time frame so that the case officer has ample time to get anything in place. In previous cases, the applicant has uploaded documents onto a single memory stick. Normally, I would be working to our core documents library rather than a memory stick. So if you're happy to liaise with our case officer on what your preference is, but if we have an up-to-date set of documents on our website, it means that parties don't have to rely on a memory stick. They can download anything they need in advance of any inquiry or hearing session. Yeah. Further written submissions, I'd hope to try again issue within the next couple of days so that initial responses from parties could be sought before Christmas, but obviously we are working to quite a tight time frame. So if parties have any issues with that, could you let me know now? I think principally it's Nature Scott. Sorry, I was hoping to seek Nature Scott's position in relation to the SPA and the appropriate assessment prior to Christmas. Is 2 weeks sufficient?
Ma'am, I suspect that would be. Again, Ms. Masson's on the call, and please contradict me if I'm wrong. But in terms of written submission on those discrete points, I think that would be fine.
Yeah, they will be fairly concise matters, so I was hoping that it's work that Nature Scott has already undertaken.
Mm-hmm.
Yes, we should have documents already good to go, so that shouldn't be a problem.
Okay, thanks. That's
Thank
helpful. It means that I'm not rushing to get something out the door before Christmas if there's no hope of getting an initial response. Then I'll take into account the festive period, obviously, and allowing the applicant more than the normal 14 days to respond. Parties might be aware that we've been working to a slightly different format in terms of statements of agreed matters. So we're now working to a template that is a statement of matters agreed and not agreed. And I will be happy to issue the template that we've been using along with the note of the meeting. It's just so that it's very clear from the outset what the points of agreement and dispute are. And that allows parties then to focus their inquiry statements and reports. So the aim is to try and get that in advance of any of the other submissions, so that we can have parties focus their attention when they're writing the reports, and so that we're not just getting information that's perhaps superfluous to the inquiry process. So I don't know whether parties have seen that recent template, but I'm happy to issue it. So I was proposing that the applicants take the lead in producing that with and to liaise with the other parties who have agreed to participate in the process. I think it would be helpful to know what Dr. Lee's focus is going to be. So if she's listening, I'm hoping that she can perhaps contribute to that process, so that we're clear on what it is that she aims to address at the inquiry. So as I said, I'll issue that with the note of the meeting, and I was hoping that parties could get the first draft of that template back to me by as early as possible in January. My initial indication had been the 11th of January, but it's not quite clear from the applicant's revised time frame whether or not you consider that's achievable.
That's the 23rd of January that we're suggesting, and I think we've put a lot of time into trying to put together the timetable. Very grateful, obviously, for your suggestion, but if I may say, I think that the timetable that we proposed yesterday better accommodates the festive period. Obviously, that's important at this time of the year, and it doesn't seem to us there's any detriment to the process in amending the deadlines. It also separates out the submission of cases in inquiry statements. So that's kind of at -6 weeks, from witness inquiry reports at -4 weeks. We would say it better accommodates the need to prepare and review the cumulative update, and then also it would still allow 4 weeks from the inquiry for submission of the reports, and then -2 weeks for precognitions. So we hope that the revisions, the tweaks that we've made find favour. We think it works. We think it's slightly better, if I may put it like that.
Okay. There's a final statement of agreed matters on the timetable I was issued yesterday, but not a first draft, so I couldn't see that anywhere in your timeframes.
The SOAM is at -7 weeks to be submitted, but a first draft.
So it's really the first draft that I was looking for earlier in January, if at all possible, so that we can.
Yes, well, if the final version's got to be at -7 weeks, then I suggest that it could be the first. It could be with the 9th of January as a first draft. Mr. Campbell's on the call. Keith, just in terms of draft, SOAM is 9th.
Yes, I mean, I think subject to what Mr. Milne says, I think 9th is achievable for a first draft.
So I had 11th of January on my timetable, which was a little bit more generous. But if you're happy to work to 11th, I'm fine with that.
I think that was down as the final SOAM, though, Mum.
No, that was really intended to be the kind of initial draft.
Right. I'd got that down as a note that was the final SOAM, but if it's
Sorry.
draft the 11th is
Yeah,
fine. We'll work to that, and then then the final SOAM, then the 23rd.
that's fine.
Thank you.
Okay, thank you. Okay, so I've set out in the agenda the timing for the various submission of inquiry reports and statements and the precognitions. So just for the purposes again of perhaps Dr. Lee, if she's listening in, so for parties taking part in the inquiry sessions, they have to detail in advance the case that they'll argue, list the documents that they will rely on, and any witnesses who will speak on their behalf, and include the topics that each will cover. So inquiry statements should set out each party's case in sufficient detail, allowing for more focused precognitions and potentially reducing the extent of the oral sessions. So again, I'd be happy if Dr. Lee has any comments on that or any questions on that to contact the case officer. We sometimes make different provisions if it's an individual who doesn't have legal representation, so we would be happy to discuss that. And in terms of giving evidence, if Dr. Lee and anyone else who's participating in the inquiry sessions, they should submit a precognition in advance, and that should provide a detailed written statement summarising the evidence that the person will present at the inquiry. It should be concise and not cross-reference any other documents. It shouldn't include appendices or other technical information or evidence such as photographs. Those should be lodged as documents by the date specified. If precognitions extend to more than 2,000 words, then a summary precognition should be submitted, and it's generally the summary precognition that we would rely on oral sessions. In hearing statements, normally our preference is that these are submitted 6 to 8 weeks in advance of the inquiry. However, I note that a tighter time frame has been requested by the applicants. I'm prepared to be a bit flexible on that, so I'll consider the requests that have been made. The conditions are another matter that's useful to get agreement on early in the process. So these should take account of the standard conditions produced by the Energy Consents Unit, and these are available on the DPA's core documents library. They reflect current good practice and the consultation responses from statutory agencies and others. So what I was hoping for would be a first draft of the proposed conditions, not necessarily with the comments of each party, within 14 days, which I think is what's on the, yep, that's 21st of December on the applicant's revised timetable.
And I can happy to report that draft conditions are well advanced, and so that's absolutely something we can do.
Yeah, that's lovely. I would just reiterate for the benefit of Dr. Lee, these conditions are required as a matter of course, irrespective of our recommendation to the Minister. Okay. So the second
just on a
sorry,
Mum.
Mr.
I was
Hardy?
just on a related, yes, just on a related topic to conditions, that we can confirm that there's no requirement for a planning agreement. I raise that now because the council report suggested there might be a need for a planning agreement or a condition in relation to decommissioning obligations, but in accordance with the usual approach to section 36 is that will be subject to a condition. I thought that's just helpful to raise now.
Thanks, that's helpful. And initially I had been looking for the second draft of the proposed conditions 8 weeks in advance of the inquiry start date, but I'll take into consideration the comments that's been made this morning, and I'll confirm the position in my note of the meeting. So normally it would be for the applicant to commence a process of agreeing the second set of conditions, the final set of conditions with the council, and coordinating the comments from the various parties. Are you happy to do that?
Yes, we'll do that.
Thank you. And at this point, I would just like to maybe perhaps check with the council. My understanding is that we're back to the arrangements of making public deposit of copies for inquiries rather than them being made available, online. I'm not 100% sure. I've not been able to get anyone to clarify that, but could I perhaps ask the council just to confirm the position in terms of whether or not the documents have to be made available locally?
I will need to I will need to double check that, ma'am. It's been a while since, well, we're now out of COVID, so I'll need to double check. And I'll come back to you on that if that's all right.
That's fine. Thanks very much. There's no need for you to confirm that quickly. I will just address in the note of the meeting that the applicant and the planning authority will coordinate in supplying any documentation that is required should it need to go on public deposit.
Certainly for normal applications now, they're on deposit. So, but I'll clarify that position in respect to the inquiry.
Thanks very much. Okay. And closing submissions will normally be invited in writing after the close of the inquiry. The purpose of those submissions is to provide a summary of parties' cases on all the topics which a party wishes to make representations on, including any evidence heard at any inquiry or hearing sessions, but they should not contain any new evidence. So in accordance with our recent practice, we have a template again for case summaries so that these can be slotted directly into the report for ministers. I'm happy to attach the template that DPA are using to the note of the meeting, and that sets out what we would expect from the various parties, and then it would not be for me to alter that when it is included within the report. The parties have any comments on that?
That'd be helpful. I've got another sort of broader point, and that is I found that experience has varied where you have a discrete inquiry session when it comes to writing up closing submissions. Would it be your position that closing submissions should be limited to the topics which are discussed in the inquiry session on L&V, limited as we say they should be, plus the policy material? So in other words, you're not.
Sorry, closing submissions can be on the party's whole case. They don't have to be focused just on the inquiry.
Right, so that's different. So that's what I was going to say, because my recent experience is that specifically has not been the case. So, for instance, a case that Mr. Mann and I were involved in recently, where it was heritage. What the reporter wanted was closing submissions just on heritage, didn't want anything else, didn't want planning balance, didn't want the other material considerations. What you're saying is that closing submissions aren't going to be restricted to L&V and actually want the whole lot.
It's open to the parties to present what they think is the important aspects of their case and include it within closing submissions. I wouldn't artificially limit it to just the inquiry sessions or the hearing sessions.
Right.
The case summary would be a more focused view of what the applicant and the council and Nature Scott's position would be, so that when we present a report to ministers, we don't alter that. That is, it makes life easier for us, but it also means that we're not having to perhaps reach a different view from you, interpret what you've said. It means that your case is directly being put to the minister if we incorporate the summary of cases.
Yes, all I'd say then is that absolutely. So, Matt, if that's going to assist you, of course we will. That is different to the way that other reporters have asked us to do things recently. If it's going to be a more comprehensive closing, then two weeks is quite short. And I might suggest that gets pushed out to, say, 3 weeks if we're going to have to deal with the whole of the case.
It's not. I'm not asking you to deal with the whole of the case. It's always been, as far as my understanding is, it's always been your ability to put in the whole of the case. It's entirely up to yourselves. But that isn't something new. What is new is the summary of cases. That's a relatively recent thing.
Yes. But what has happened is reporters have restricted the ambit of closing submissions. Said, I'm not. I don't want closing submissions on anything other than those topics that I've heard in the inquiry or the hearing session. So we've had that in the last 2 or 3 inquiries. If that's different, and what you're saying is, look, there's an ability to put in submissions on the whole of the case, I suspect my client will say, well, look, we don't want you to, Mr. Hardy, to sell us short. If that's the invitation, then they will be longer, more comprehensive closing submissions than normal. If that's right, and you're not seeking to circumscribe, I'm just just suggesting that 3 weeks might be better than 2. If it's just L&V and policy, 2 is fine. If it's a broader closing submission, then I think 3 may be more sensible.
Okay, I think it's only fair to the other parties who have said they would participate, including Dr. Lee, that she's not limited only to that, because her objection was wider than the sessions that we're holding. So it would be unfair to say we're restricting closing submissions only to that. She has the same entitlement to make a closing submission. So my view is that the closing submission allows the party to basically summarise their case.
Of course, if that's helpful, then we will do that. So I think my request would be for 3 rather than 2 on that basis.
Okay, I would just say it has been done in 2 weeks in the past with other inquiries. I'll reach a view on that. Okay. In terms of the format of submitted material, all parties are requested to submit statements, recognitions, written submissions and documents in electronic form to the DPA and copied to other relevant parties. The exception being any large format plans or visualisations which would be issued in paper form. I was going to ask doctors, any other party require additional copies, paper copies of the documentation at this point in time? Scott, I'm not sure if you have the paper copies to allow you to participate in the inquiry process. If not, if you could perhaps let us know when the case officer will liaise with the applicant for any additional copies that are required.
I think we have what we need, ma'am, but we'll certainly be in touch if there is anything missing or additional copies are required.
And that offer is open to Dr. Lee if she's participating in the process and requires paper copies. I'm presuming the applicant would be happy to provide a copy.
In that regard, can I just say, maybe we're trying to be as sustainable as we can. What we've done before, and I think it works well, is that CMS can provide an extranet with all the folders, with separate folders for all of the application and inquiry documents, and that can be quickly updated. Once that's been set up, what's happened in the past is that entry to that extranet facility has been offered. So, and we'd be happy to do that in this case. So rather than, I think you mentioned a data stick before, CMS has got a pretty sophisticated document hosting service, and therefore people will, if that's useful, we will set that up and make that available to everybody else. So that may cut down the need for printing.
My understanding is that it's really just the visualisations that we would need to have printed, and that all other documents will be updated to the DPA website so that they're accessible to parties. So it's really perhaps if Dr. Lee's participating in the landscape and visual session, she may require a copy of the visualisations to assist her. So if that's the case,
a matter of her. I mean, yeah, well, leave that obviously for her to say. The offer is there, and in terms of cost and sustainability, it seems to us that's a proportionate thing to do.
We're trying to work to the simplest format possible in documents, because the swapping of memory sticks at the last minute obviously has some potential problems, and then if there's Wi-Fi issues, depending on where people are working from, sometimes the memory sticks don't allow you to click on the hyperlink. So what the intention is all document management is organised with the case officer, who will then ensure that the documents are available to download from our system for anyone participating.
Don't want to take up too much time. It was actually interesting that USB sticks were actually the saviour at a recent inquiry, where at the venue the Wi-Fi was crippled. It couldn't cope with all of the laptops, so nobody could get on, and we handed out USBs like sweeties. So I get the general point.
To be honest, I probably will take a memory stick wherever I'm working from.
So will we.
Yeah.
Yes.
It probably makes more sense, but there's been a bit of fluctuation in terms of who provides memory sticks and when, and sometimes it can get a bit tricky. I think the last inquiry I did, we kept it to, I had made sure we had all documents available, but the case officer will be happy to discuss directly with
We'll
the
work,
parties
exactly.
the
We'll
best
work
way
together. We'll be
to do
very
it. Yeah.
sensible and helpful.
Yeah. Okay, thanks. That's much appreciated. Okay, and moving on to item 9.
Ma'am, sorry to interrupt. May I make some very brief comments on the timetable? This will not take.
Certainly. Sorry,
Hopefully,
I
this
thought
will
we
not
had
take
sort
long.
of mostly covered it, but I maybe swept through that a bit quickly. Sorry.
That's very helpful, and it's really just to confirm that Nature Scott strongly supports the applicant's proposed timetable, which will be easier for a number of reasons, including availability of witnesses for Nature Scott to work with. And having made that general remark, again, due to availability, it would be very helpful, and this is just picking up that on the second page of what I've printed of the applicant's proposed timetable, inquiry statements, it says, are due -6 weeks for the inquiry, week commencing 30th of January, subject, of course, to any wild land topic extension. Could the inquiry statements please be due on the 30th of January? Could inquiry reports please be due on the 13th of February, not later in those weeks? That will enable our landscape witness to consider the inquiry statement before another commitment. And because of our landscape witness's commitment, he will not be back in the country until 27th February, so would not be able to submit his precognition on that date. I'm therefore instructed to ask if precognitions could be lodged -1 week from the inquiry, and hopefully with the inquiry reports having very full, that would not cause too many difficulties.
It does make it a bit tight, I have to say. 2 weeks is normally the minimum.
We're very keen, subject to the wildland discussion, not to derail the inquiry taking place on the 13th. It's just physically not possible for our landscape witness to prepare his precognition for the 27th. Now, I dare say if to add an additional week is not met with a great deal of enthusiasm, if it would be possible even to reduce the fortnight down to 10 days, then...
I was going to say that, Mr. Mann. I mean, that's very helpful in answer to the previous dates. Rather than week commencing, yes, happy to commit to those dates. And then in relation to precognition, not later than, but with the expectation that, if it can be done sooner, and if it was a 10-day period, we'd be happy with that. I think if that keeps the inquiry on track, then we would say yes to that.
Right. Thank you.
Okay. I had kept the timescales as far as possible in accordance with the DPA guidance, but bearing in mind that this looks like it's going to be a relatively short inquiry, I'm prepared to come and go a bit on the time frames. So yeah, I'm happy. 10 days gives me at least a reasonable amount of time, bearing in mind depending on whether, if it's virtual, it's less of an issue. If I've got to be travelling to an inquiry, there's a lot of things to prepare and a bit of time lost in advance of the inquiries. So 10 days certainly makes it a bit more helpful to myself.
Thank you. That's very much appreciated. If that finds its way into your final note of this meeting. The only other that's the timetable. I am very grateful to the applicant for circulating that in advance of this meeting and allowing Nature Scott to consider that. The only other point was to return, as I had said at the very beginning, Nature Scott has some remarks to make regarding the proposal to submit further environmental information. And I'm not sure when you're wanting to discuss that, and if Mr. Hardy is has anything to say about that first before I set out Nature Scott's brief position.
I was going to come on to that on agenda item 10, miscellaneous. So, if you, I'm happy to address it now. It's not fixed.
Well, if you want me to go first, I don't know what you're going to say. We've been getting on very well, Mr. Milne, so far. I don't know whether it's a part.
I don't think this will upset you. So
very good.
do you want me? Shall I explain where I'm coming from?
Exactly.
Because
you tell me what you think first. Yeah.
So, in Nature Scott's letter of 24 July 2022, which I've referred to a couple of times, on page 11 there is a couple of sentences which explains that nighttime visualizations have been provided from 4 locations at a range of distances and elevations. Whilst the visualizations give some indication of the proposed lighting, we consider that they may not present an accurate representation of the intent of predicted turbine lighting. We advise that these nighttime visualizations may underrepresent the proposal and cannot be relied upon. Now, that's a point which will form part of the evidence which is to be laid at inquiry regarding nighttime effects on the NSA. So what Nature Scott had wanted to do was to raise at this pre-inquiry meeting that remains their position, and to ensure that the applicant knew that and had an opportunity to remedy that if they so wish. I appreciate that's a matter for the applicant. And then reading the other day about the intention to lodge further environmental information, I did note that nighttime visualizations, unless I've missed something, are not expressly referred to there. So it may be the applicant has taken a decision on that. Again, I note that you are intending to discuss the detailed requirements of the further environmental information directly with Nature Scott. So I mention this point because it seems fair and appropriate, and Nature Scott are happy to discuss that further, or indeed I'm happy to explain in more detail what the concerns are now, although that is getting into some technical detail and that might not be the best use of time or appropriate to do so.
I don't have any problem with the parties having a discussion on that matter separately from the pre-inquiry meeting, but I would be interested to hear the applicant's view on that.
Yes, what I was going to say about the additional work is in relation to the cumulative assessment that was set out in the email. You've seen that scope of works. There are 5 parts to that. So an updated list of cumulative projects, the updated FEI figure 6.9a, the updated cumulative ZTVs, some updated wireline visualizations in relation to 6 viewpoints, an updated cumulative assessment text in relation to the NSA. So I think the cumulative cut-off point's been agreed as the 7th of December, and with a request from you, Mum, in relation to that work being required for the inquiry circulation on the week commencing 23rd of January. It doesn't sound as though that, Mr. Mill, that part of it at least isn't a concern. In relation to nighttime lighting, we'll have a discussion about it. If there is going to be anything, we would include that in the same package of material. I'm not suggesting or committing to the fact there will. It's worthy of discussion. And in the same way, in your note, I suppose you could say, if so advised, or something like that, that if the parties in discussion so advised, that would also be caught by a request for information for the purposes of the inquiry, just so that we get the notification procedure right. So I think it's a matter, it's not a matter of off this call, it's a matter for discussion between us and Nature Scott. I think, Mr. Milne, is what I'm saying.
And that sounds fair to provide just a little bit more information, should that be helpful for the reporter's note. It's nighttime visualizations taken from viewpoints 10 and 13.
Thanks. Moving on to before we move on to item 9, does anyone have any further comments on the timeframes or the submissions?
No, just an invitation really through Mr. Milne to let's get meetings in the diary. You know, we have got a short time scale. We can meet it, but let's. I'd encourage the parties to fix dates after this call. You know, today, so that we can make progress.
Agreed.
Happy to hear that. Thank you. Okay, and in terms of item 9, site inspections, I have the same issue as Nature Scott does in terms of the time of year, the weather, the limited light. It's my proposition that I'll undertake my site inspections on an unaccompanied basis after the inquiry. Excuse me, I've got a terrible cold at the moment. I have a reasonable working knowledge of the entire area, so I'm content to work on that basis, and that if it's agreed that a visit to the site is necessary, then I'll advise in advance and arrangements can be made, I'm sure, prior to the inquiry. Does anyone have any comments on that?
No, we're happy with that. What we can do is get an agreed list of suggested viewpoints for you to visit. I think that's standard practice, but we can work with Nature Scott and the councils to get that together. Yes.
If you could run that past Dr. Lee as well,
Sorry,
that would
Dr.
be helpful.
Lee, yes, we'll agree, and then put that to Dr. Lee if she wants to add anything to it.
Thanks very much.
Yes.
And if you make that available to the case officer, they'll get that to me in due course.
Thank you.
And as regards Nature Scott's position, of course, that's all understood, and we'll certainly suggest viewpoints. Ma'am, to forewarn you, some of those will be in North Avon. That's probably quite predictable, given the nature of Nature Scott's objection.
Okay, thank you very much. Thank you. Certainly don't want to be doing it at this time of year. Okay. So moving on to item 10, miscellaneous. Sorry, I have got such a sore throat today. So the first thing I wanted to note was that similar to the further information that's to be supplied in January, the aviation assessment update of the 31st of March 2022 and the response dated August 2022 to Nature Scott's objection that have kindly been provided by the applicant are not in the Energy Consents Unit website. So I just wanted to seek parties' views on whether or not that information was something that required to be advertised, or whether they felt I had to formally request it for the purposes of the inquiry. Can I seek the applicant's view on that first?
That's a detailed matter about which I don't know, but I would always err on the side of caution unless either Mr. Potter or Mr. Campbell want to say something different. I request it for the inquiry and so we don't fall foul of an advertising problem.
Does Mr. Potter, do you have any?
Yeah, my interpretation was that it was an ECU website. I've just gone to have a quick look, but yeah, I agree with what Mr. Harvey said. It would be keen to avoid any pitfalls with the advertisement.
And council, are you quite content with that process? That's a matter that's left for me to request for the purposes of the inquiry?
Yes, ma'am.
And Nature Scott, any comments?
Nothing to add on that point. Thank you.
And I'll include my comments on that and on the further environmental information when I issue the note of the meeting. So no further comments on the further environmental information due on January 23rd. The DPA contact, most of you will probably already know, is Stuart McCluckie, and he's the first point of contact. All his details are provided in the agenda, his phone number and his email address. If you have any questions or queries, he's the person to speak to. And if we are having a virtual inquiry, I had hoped to start at 10 AM on the first day, with subsequent days commencing at 9:30 and concluding around 4:30 to 5, with short breaks morning and afternoon and a break for lunch for an hour at a convenient time between around 12:30 and 1. If we do go down the route of a virtual inquiry, we're likely to require additional short breaks, obviously. But I think I'm probably keen to hear at this point again, just to reiterate, if parties don't have any strong preference for an in-person inquiry.
No, you've heard my views. It's always interesting. You always find something new on these calls. Recently, the impetus has been the other way, to make them in person. However, notwithstanding the guidance, we don't have a strong view. We had assumed that it was going to be an in-person event, but if you think that the efficient way to do this is virtually, we have no objection.
Had the parties been broader, I would probably have agreed and been quite content to have an in-person inquiry. But I think in the interests of efficiency, given that the parties we have available are all readily, available online, with the exception perhaps of Dr. Lee. But I will seek Dr. Lee's view on that before I confirm the position.
Thank you.
Okay. Good. The inquiry and hearing sessions would be live streamed if it was a virtual event, which means that if parties are available to get themselves to somewhere where they can get decent Wi-Fi connections, then they are able to view and participate online, and thereafter the recordings would be available as normal on the DPA website, details of which will be provided in the note of the meeting. Okay. So moving on to any other matters, does any party have any further comments on any points before we finish today? The applicant first.
No, we've covered all the points that we've got. Thank you.
Nature Scott.
No, thank you, man. That's been very helpful. Nothing else to raise.
And the council.
No, thank you, ma'am.
Okay. Thank you everyone for your participation today and for putting up with my cheeky boys. Hopefully that's it. Enough to get us going on, and if there's any questions at all, as I say, if you contact the case officer, and I'll do my best to get the note of the meeting out this week. Thanks again, and we'll speak again, no doubt, before the inquiry, just to confirm the positions. Thanks.
Thank you very much
Thank you
indeed.
very much.
Bye-bye, Mum.
Bye.
Thanks for your time.
Bye.
Thank you.
Thank you.
Bye.